if at all he can join.
Yes, ma'am.
Oh, sir, thank you so much. Thank you. Sir is joining in 1 minute.
That's great news, ma'am.
Ma'am, I think sir had joined. Uma. Yes.
Good afternoon, sir.
Good afternoon. Good afternoon.
So
Good
nice
afternoon,
to meet
sir.
you on this platform, sir. We could
Thank
not
you.
meet personally anytime, but this is a good platform at least. to meet
It's
you.
my great pleasure. Bharti Vidyapit always
Yes, sir.
welcomes me.
That's so true, sir.
Hmm.
But
Thank you so much, sir.
Tari, I would say, ma'am, this would be a privilege also for the institute, for me as well, as I've been
Yes.
sharing the platform. पण उमाप सरांसारखा गायडन्स असेल तर आय गेस इट इज सोन्याहून
Special thanks to Ujjwala Vendale, madam.
Thank you, sir. Thank you.
Of course,
Yes,
sir.
Thank you so much, sir. सर आता
Yes.
बरेचशा गोष्टी लाईंड अप आहे, तर आम्ही
Okay.
आपल्याला असंच व्हॉट्सअप करूया. आपण
Yeah.
प्लीज तेवढ्या 1 तासाकरता आपला वेळ दिला परत तर
नक्की नक्की
थँक्यू सो मच.
नक्की नक्की. Yes, yes.
चला करिश्मा मॅडम.
Yes, yes, ma'am.
जयश्री मॅडम, लेट्स स्टार्ट.
Yes, ma'am. Just 1 minute.
Yes,
Karishma.
yes. Okay, a very good afternoon to one and all. On behalf of Bharti Vidyapit, deemed to be University New Law College, Student Progression Cell, I, Karishma Pushkar Patil, Assistant Professor, New Law College Pune, take this privilege to warmly welcome you all for a webinar on topic Skill of Argument and Art, organized by Student Progression Cell of New Law College in collaboration with Bar Council of Maharashtra and Goa. Before we move to the informative session, on behalf of Bharti Vidyapit, deemed to be University, New Law College Pune, I wholeheartedly welcome today's resource person, Advocate Dr. Sheetal Babar ma'am. I would also like to welcome our respected guest, Honorable Advocate Rajendra Umap sir, Vice Chairman, Bar Council of Maharashtra and Goa. I further extend my greetings to our Honorable Dean and in charge Principal, Dr. Ujjwala Vendale ma'am, and all the learned faculty, my dear students, and all those who have joined us for the webinar today. May I now humbly request our beloved Dean and in charge Principal, Dr. Ujjwala Vendale ma'am, to give welcome address for our guests. Ma'am, please, over to you, ma'am.
Thank you so much, Karishma. Good afternoon, everyone. Welcome to this webinar on skill of argument and art, organized by Bharti Vidyapit, deemed to be University New Law College Pune Student Progression Cell in collaboration with Bar Council of Maharashtra and Goa. Today, to train our students, we are blessed by an eminent personality of law fraternity, a great guide and help to the students in Pune. Honorable Advocate Dr. Sheetal Babar, practicing lawyer, Pune District and Sessions Court. Welcome, madam. I
Thank you,
take this
sir.
pleasure to welcome you, and I'm so very happy that you have really graced this occasion and you are going to enlighten our students on argumenting skills. Thank you so much, ma'am. I also wholeheartedly welcome Honorable Advocate Rajendra Umap sir, Vice Chairman, Bar Council of Maharashtra and Goa, who has always supported the students' progression cell and promoted the law students to become best practicing advocates. Thank you so much, sir.
Thank you, ma'am.
Now, with your due permission, I'll just formally introduce you to Bharati Vidyapeeth. And here I take the pleasure to inform you that Bharati Vidyapeeth New Law College is ranked 63rd by NIRF. The institutions of Bharati Vidyapeeth were accorded deemed university status in 1996 for its academic excellence. Bharati Vidyapeeth is accredited with A+ grade in 2017 by NAC and has category 1 university status by UGC. Bharati Vidyapeeth has always been academically excellent and always has tried to serve the students from rural and urban categories or areas. And all this has been possible only because of Honorable Dr. Patangrao Kadam Sahib, the founder of Bharati Vidyapeeth deemed to be university, a visionary who at the age of 18 years decided to establish Bharati Vidyapeeth as distinct educational institution. Today, Dr. Patangrao Kadam Sahib is the guiding star for whole of Bharati Vidyapeeth fraternity. We have amongst us a zestful patron of Bharati Vidyapeeth, and he is Professor Dr. Shivajirao Kadam Sir, Chancellor Bharati Vidyapeeth deemed to be university, member UGC, member NAC, and recently on 6th of May 2021, last year, Sir is awarded with Excellent Contribution to Education Sector Award by CMI ICT Association of India and Electronics World's Communication Awards. Our young and dynamic patron of Bharati Vidyapeeth is Dr. Vishwajit Kadam Sir, Pro Vice Chancellor Bharati Vidyapeeth Secretary Bharati Vidyapeeth, Member AICTE, and Honorable State Minister, State of Maharashtra. Sir, Honorable Minister, is an excellent visionary like Sahib and is stepping on the same path of success and very positively is carrying forward the torch of Bharati Vidyapeeth to more greater heights. Supporting Dr. Vishwajit Kadam Sir is Professor Dr. Manikirao Salunke Sir, the Vice Chancellor Bharati Vidyapeeth deemed to be university, who is a disciplinary and a brilliant administrator. Today, under the excellent guidance of our beloved patrons, New Law College Bharati Vidyapeeth has been consistently ranked among the top law institutes by Career 360, India Today, Education Post, and so on. New Law College is recently an awardee of Best Law College in India for Research and Pedagogy by IIRF Education Impact Awards, New Delhi. Madam and Sir, let me tell you, New Law College has always encouraged the students to take up the field of their interest and to train the students as per the requirement of respective field. And the college has started different cells like Madhyasthata, Environment Cell, Community Development Cell, and one of the cells is the Student Progression Cell. Now, the Student Progression Cell today is functioning very, you can say progressively. And of course, the main core objective of this cell is educating and preparing the students for court practice, judgment writing, drafting, and presentation preparations. And we also aim to train the students to prepare them practically to face the challenges in the court and in the fields. The objective and of course the mission of the cell is to educate and prepare the students to take judiciary and practice and teaching as career options, and also to educate and prepare the students to help the poorer sectors of the society in order to provide them legal aid. We, through this cell, are planning and of course are in managing certain events, and these events are one-month courses in collaboration of Bar Council of Maharashtra and Goa, wherein we are planning judiciary exam preparations, net set exams, then public prosecutor exams, advocate on record exams, all India bar exams, and all these exams we are going to train the students practically, and of course educate them for more than 30 subjects which are so required for all these particular subjects, for all these particular exams. When we talk about training, we specifically are going to focus on legal drafting, judgment writing, preparing of appeal and revision proposals on given facts, and essay on different on recent developments in criminal law. We are also going to do this particular trainings through different seminars on professional ethics, mooting skills, scope in legal fields and opportunities in coming futures in different law fields. So the student progression cell is continuously going to work under your blessings. And once again, I welcome Advocate Dr. Sheetal Baba Madam and Advocate Umap Sir, and express my gratitude towards both of them for gracing this occasion. Thank you so much. And over to you, Karishma, again. Thank you so much, ma'am and sir.
Thank you so much, ma'am. Now it is my honor to introduce Honorable Advocate Rajendra Umap, sir. Sir is currently serving as the Vice Chairman for the Bar Council of Maharashtra and Goa. Sir was ex-Vice Chairman, All India Handloom Board, Ministry of Textiles, Government of India, from the year 2008 to 2010. Sir is trustee at Chinchwad Devasthan Trust, Morgaon, Siddhatek, from the year September 2017 till year September 2024. Sir is also chairman at Life Care Foundation. Sir is vice chairman at Shirul Taluka Janhit Pratishthan. Sir is secretary at Vikas Pratishthan Chandan Nagar, Taluka Haveli District, Pune. Sir was also former president at Pune District Bar Association for the year 2013 and 2014. Sir, we welcome you for our webinar. Yes, thank you, sir. Further, I am profoundly delighted to take this opportunity to introduce our resource person for the day, Dr. Sheetal Babar, ma'am. Ma'am has completed her PhD in copyright law from Savitribai Phule Pune University. Ma'am has teaching experience of 15 plus years. Ma'am is also founder and director of Law Straw Private Limited Pune and co-founder of Law and Beyond, the Finishing School Pune. She is senior consulting partner at APJ Legal Associates Pune, handling IP cell in charge. Ma'am has received different prestigious awards and also has conducted various webinars on dynamic topics in the field of law. Ma'am, we welcome you. Now, may I request ma'am to enlighten us on the most important topic, that is argument skills, which is needed for every lawyer to shine brighter in the field of law practice. Over to you, ma'am.
Yes. Thank you so much. Thank you so much. It's too much of a pleasure. It's a great pleasure, in fact, to be there along with these dignitaries. Umap sir, I mean, Karishma ma'am, I guess you would connect with me. There is no need of any introduction to this man because I've been
Definitely.
fortunate to see his career as a president of Pune Bar Association, wherein my own brother was working under him as a vice president. So I have seen in and out his that desire to work for the lawyers, and he's been doing so fantastically, talking about, I mean, the recent one, sir, if I'm not wrong, COVID madla apla lawyers insurance is the most fantastic work, I would say. I mean, खूप लहान तोंडी मोठा घास घेतल्यासारखं होईल हे सरांचं कौतुक करणं म्हणजे. But
शीतल मॅडम, तुम्हाला फक्त 1 मिनिट मी इंटरप्ट करतो. मेंढाळे मॅडम, करिश्मा मॅडमचे सासरे एनडी पाटील सर, मी सेक्रेटरी असताना प्रेसिडेंट होते. थँक्यू.
Yes. So basically, I have seen Umap sir working actually onto the field and working for the lawyers. So this is Umap sir, this is a privilege for me. This is a blessing for me to share this dais online though with you. Bindale ma'am, I have no words to say anything about you. This would be a little exaggeration to state as to the lady empowerment and all of those boosters we get it from you. So honestly, this is so fantastic to be there with you onto this platform and looking at these dynamic two ladies again, I would say yes. There is nothing less for a women empowerment onto this platform. So,
Sheetal, I interrupt you again.
Yes, sir.
Bendare madam, just at Thane, there was a conference of Bar Council of Maharashtra and Goa, and in that conference, we have made resolutions. One of the resolution is there should be reservation for women
क्या बात है?
three members should be from lady. So we
Oh,
have made a resolution. Secondly, we are already published books regarding judicial service as a career. Then we are I have also made a book of AIB exam since 2010. This exam is conducted by Bar Council of India. So that book is also with me. So at any time, I will guide you all, and I will be very happy to share all the thoughts. Thank you.
Thank you so much, sir. So we
Yes,
would really go through this book, and we would really want to have one copy from you, sir.
sure, sure, sure. I will
Okay,
share.
sir. Yes, sir.
Thank
Thank
you.
you so
Thank
much,
you.
sir. Thank you.
Thank you. Ashital,
Chale?
madam.
Yes, sir. Yes, sir. Thank you so much, sir.
Yes.
Now I guess
All the best to you. All the best to you.
thank you so much, sir. Thank you so much.
Yes.
Now, coming to the topic, in fact, I guess all of the students might be a little buzzy to hear what all these skills and argument skills and in those argument skills, talking in front and speaking in front of a map, sir, would be a little, I would be a little hesitant to, deliver this session. But yes, as this has been assigned task for me, yes, let us start up with what basically these arguments are. How do they help us, and how basically we help ourselves to grow up or enhance these skills or develop ourselves with the skills of arguments. So talking about argument, what is argument? Now, argument can be anything. I arguing with my husband, I arguing with my son, I arguing with my daughter, two people arguing with each other. There might be a group arguing with each other. There might be thousands and hundreds of people arguing with each other, or it might be a senior arguing with junior, or junior vice versa arguing with a senior. So when it comes to argument, actually it is completely an evasive term. Argument in general is wherein you're putting up your own contentions, probably not to prove anything, probably not to state anything, probably just to non-corroborate what the other person is stating, or just to defend someone else's point. So argument in all of these cases, depending on to the circumstances or situations, completely differ from each other. While talking about these arguments, just to define what argument is a mere statement or statements which we put forward in front of an authority to express ourselves, to prove our points, to prove someone else's points. Now, coming up to this proving of someone else's point, here we come with a concept of a legal argument. So what do we mean by legal argument is more important to understand than rather understanding what is an argument. So what is a legal argument? From the nomenclature, we let understand what is a legal argument, isn't that? So legal argument is something wherein you're putting your own words, you're expressing your thoughts, you're expressing your opinions to someone who has a legal authority. When I say so, let us have a scenario. I'm a lawyer, you the budding lawyers. So you the budding lawyers, respectively, in your own situations, you are standing in front of a court, or in fact, let us have a little more legal statement. You are appearing in front of a judge. While doing so, while you are appearing in front of a judge, now you have so many stages which you have come across. Maybe from the filing stage, you do not need to stand in front of a court or appear in front of a court. So you just go to an office, you submit the documents, and you submit your appeal, you submit your application, you submit your complaint, whatsoever it might be. And then depending on to every single crossing up of every single level of acceptance of appeal, or maybe acceptance of that application, hearing of that application, witnesses and depositions and so many things, finally you come up to a point wherein you say, my case is at the argument stage. While stating so, I would say you're completely wrong. You cannot have one argument stage. There are 3 argument stages as per my experience. It's a pre-trial argument stage. It's actually trial argument stage, which you might be contending of, and there is post trial argument stage as well. So when we talk about these three stages, let us understand what all these things are. Now you're standing in front of a judge and you need to argue. And it completely depends on what you argue. Your client, who has a complete faith in you, do believe that whatever you're going to express in front of the judge today is going to be a fantastic argument, and that argument is going to convince the judge, and he or she might be giving a judgment or deciding the case in favor of your client. So there are hopes, there are expectations. So argument do not come near with argument or legal argument as a tag. It comes along with so many things together, so many emotions together, so many feelings together, so much of research together. So while we actually define this legal argument, we have to understand every stage of your argument, every stage of your case, every stage of your trial, every stage of your appeal. So while I say there are three stages, the very first stage is pre-trial stage. What do I mean by that? The pre-trial stage of an argument is when a client comes to you and he gives all of those respective instructions to you based upon which you think that you are going to structure a particular argument or structure a particular theme for your case. Not every case do have a same theme, isn't that? Or let us take a little legal element of this. Not every single case has the same theory you will be applying. So you might have hundreds of murder cases, thousands of rape cases, lakhs of theft cases, robbery cases, whatsoever. In every single case of whatever number you've gone through the cases, defended the cases, all of these cases are particular in themselves. So you just cannot hold the same theory for your arguments, which you are supposed to develop at a particular stage, what you call as argument stage of hearing. Hence, the pre-trial stage of argument is most important. What do you do in this case? What do you do in this particular stage? When I say it is a pre-trial argumental stage, that is the case when you actually mug up all of the instructions given to you by your client. You literally mug it up, and that's the word I can say. So mugging up all of the instructions, and they have to keep on rewinding into your mind. You just cannot take instruction once. Practically, it might be once, twice, thrice. But what I feel as a lawyer is these arguments need to be continuously rewinding into your thought process. Because every single time you think about the instruction given by your client, you do acquire a new set of facts and new set of series of facts. In the first time you actually mug up the instructions from your client, probably you must have, or you are humans, I am human. So we are actually used to miss some of the other things, miss one of the other elements. So probably first time you take the instructions from the client, they might reveal you 50% of the facts. Second time you call up and these instructions, 50% of instructions which you have received in your first element, first meeting with your client, should be again rewinding all the time into your mind. Second time you call up your client and you take the same instruction. You tell him or her, whatsoever it may be, or any gender basically. So when you talk to your client, again give me the same instructions. There are something new things which are coming up. So when it comes to third time you taking the same instructions from your client, probably there is something which you have not heard in the first and the second set of facts or instructions which your client has given you. So simultaneously, and this can only happen when you have rewinding process of complete factual things, corroborating of all of these facts or series of facts all the time into your mind. While you do so, that is first stage where you are subconsciously creating or structuring your arguments. That's the first stage or step wherein you are building up your own design for arguments. And that is the very first, or that is the beginning wherein we say you start actually forming up all of those, every single corner of your argument, every single element of your argument is basically thought of in this process, which is pre-trial argument process. Then, of course, comes the second stage. I mean, then again, the very first stage, that is pre-trial stage, I would say is a raw stage. Whatever you take instructions from your client is one side of the coin. There are two parties always, so there might be multiple parties at points or at times. So when you talk about these things, you just have one side of the coin. So pre-trial arguments are those foundations, or that is the foundation on which you are ultimately going to create or design or structure your actual arguments. So when I say you build the foundation, you actually lay down the foundation at the very first stage while rewinding all of the process of corroboration of the facts, the series of the facts, the calculations of the times, the presence of a number of people there or presence of no person there, all the possibilities and probabilities. While into the court, in the second stage, you come across certain facts which are not revealed by your client. And then that's what you could say, sometimes it's a boomerang, because you have actually structured your arguments. You know what theory you are going to apply into this particular case. And suddenly you come to know that, oh my God, there is this another side of the coin, which I never knew. My client didn't even bother to tell me that simple fact, which turns up the whole thing or whole defense of this case. And once again, then you restart the very first stage of pre-trial preparation of the arguments. So it isn't an easy process to start with an argument, to start speaking about something. There, of course, are these a number of efforts which you have to go regularly without any gap in between. So then I say you go back to the square one. You then again start corroborating the same facts, a series of facts. Then you start up with the same base of the argument. Then you take up all of these new facts which are added by the opposite party by whatever means. Maybe few witnesses, few experts who come onto the stage of hearing, into the stage of hearing, they might reveal few things. Then again, mixing and blending up of all of these new elements into the old elements, old ingredients, putting up, formulating, creating a new formula, you come up with a new theory. While you do so, you then at the time or stage of hearing are so unfortunate because simultaneously doing hundreds and thousands of things together. You're talking to your client, you're talking to the investigating officer, you're talking to the experts, you're talking to simultaneous experts as a second opinion. If there is any valid expert into your case, you're talking to some another who is expert into medical jurisprudence, for example. While doing so, you are then again creating and building a new theory every single day for your case. While doing so, at the final stage of your hearing or arguments, you come to know that there is a transfer of your judge. Does that make any difference? Now, that's ultimately nothing to be considered for skills of argument, but yes, all of your skills while you were developing a theory for your arguments were also based upon the judge's characteristics or features. Whether he's convict-minded, whether he is not a convict mind, whether he is liberal, whether she is not liberal, whether she belongs to a conventional school or an old school, or whether she belongs to a liberal school. All of these elements rather play a vital role in building up your theory and putting up your arguments. And suddenly you come to know that you are going to argue in front of a judge you are not at all acquainted with. I mean to say, you're acquainted with is you do not know that judge because he or she is completely new one, and you do not know anything about the judge. That is what I mean to say by the acquaintance, professional acquaintance rather. Let me not put it up, or let you not mug it up into a very wrong way. So talking about all of these things, you come up with this ultimate piece. There is a completely new man who does not have, or who doesn't know what has been gone through while the hearing stage, and suddenly at the argument stage, you have to argue in front of the person who is absolutely innocent about your case and just have read the case and have made the research. There's always the two elements, the field work and the academic work, both of them. The blend of both of these can only give you the perfect results. And now the person who's sitting in front of you has academically, with all the intellectuality, put in the intellectuality to understand and interpret the every phase of the stage. And now he or she is going to hear you. Now, sure, you might change the theory of your argument, because earlier theory of the argument was with an element into it or ingredient into it that judge is a convict mind. Judge is liberal. Judge is not liberal. Now you do not have any theory based upon this characteristic of a person who is designated to hear or authority to hear your case. And that is when the whole twist comes. So how do you manage with this? And then there comes the third stage, the post-argumental, or rather the post-trial stage. What is this post-trial stage? Sometimes, as in a few of you all must be having a legacy of law. We know sometimes a de novo trial is expected because there is some new piece of evidence which is entirely going to change the facet of a case. At this stage, a trial has already been conducted, and now you're going to conduct the same trial with a new perspective. Sometimes there is review, sometimes there are revisions. These are stages where you are going to argue your case twice. So for all of these scenarios, you need to have certain skills. What are those skills which you can implement, execute into the situation, and it becomes easy for you to mold, amend, change, twist your arguments which you already have been prepared with. So what do you need for preparation of arguments? For that, you have to understand two things. For preparing an argument, you need to understand whether you are going to argue orally, or now these days, I mean, when decades back, there was only oral argument which was more convenient for the lawyers. For the lawyers who had wonderful skill of oratory. There also are lawyers who do not belong to the category of having wonderful oratory skills. There might be lawyers, or some of yours as well, the budding lawyers. You might not be very good with your communication skills, or you might be an introvert person, but you want to be a lawyer. While we talk about all of these things, say for example, Sheetal is an introvert and she is not confident to go and stand and appear in front of a judge, but she wants to argue. Now there is a simple mode. I mean, this always was there in the provisions of CPC as well as CRPC. So let it be a civil or a criminal procedure. It always existed, but the more convenient way of putting up arguments decades back was oral. The provisions also provide us for written arguments. So now here you need to understand what kind of arguments you are preparing for. Of course, for both of these kinds of arguments, let it be oral or written arguments, you ought to know all the basics of arguments. We'll be coming onto that point as well. Basics are same, but there are certain changes or there are certain different elements which can be applied for these two categories of arguments. So what are those skills you need to have if you are generally preparing for an argument? And then we will just categorize this into oral and written argument. So what do you need to prepare for an argument at any of these three stages? So let it be a pre-trial, let it be a mid-trial, and let it be a post-trial argument. What all things you need? The very first thing you need is reasoning. What is reasoning? Why do we argue basically, or what basically argument is? Argument is nothing but reasoning, inferring, or deriving something. So it is RID, R-I-D. Reasoning, inferring, or deriving something. What is that something? That's an argument. And where do you, how do you reason? Where do you infer from? Where do you derive from? It is through the facts of every particular case. How do you reason and how do you infer and how do you derive something from the facts? You need to have a skill of analytical reasoning. You need to have a comparative perspective, and you need to have critical thinking while you develop or while you build your or you structure your arguments. Unless and until you think by these three ways, you cannot reason anything, you cannot infer anything, and you cannot derive anything. So you have lots and lots of information in front of you. You have to derive or you have to segregate all of those facts which are essential to structure your argument. Filtration is more important. What is that skill which helps you filter is critical and analytical thinking. Have the sequence of the facts. Let the sequence, while you are sequencing or while you are putting up the fact into the series, let the facts be, we also call it as elimination process. You eliminate those facts which you feel as to are not important. What remains is the filtered series of the facts. And for this, of course, you need to have analytical thinking. You need to analyze each and every fact and then corroborate each and every fact. And based onto this corroboration, you need to come up to the inference that amongst all of these facts, I infer that this or these are the facts which are significant for designing my theory into that particular case. Do you really need to compare? Of course, yes. Comparative study, comparative analysis, or comparative thinking helps you out to develop or structure your arguments. Take hundreds of case laws. And once you take 100, I mean, many of y'all must be experienced mooters, researchers, speakers. And they might connect to me when I say so. When you are researching something, you take all of those cases, you take all of those judgments, the landmark judgments, the favorable judgments together, you compile them together, and then probably your juniors go into the filtration process. While you do so, you need to understand the comparison, or you need to analyze comparatively each and every fact of the case, each and every principle of particular case, and then comparatively you need to understand which is that basic element, which is that basic principle which shall definitely help you build your case stronger. And hence, the foremost thing to develop your argumenting skill or argumentation skill is thinking. You need to think. You need to think critically. You need to think analytically. You need to think comparatively. While you do so, you come up to an inference or a derivation to build up your case. Secondly, what is that essential thing which helps you enhance your ability to argue in front of the court? Your research. How, when, and by what means you research is important. Of course, all of us know what are precedents, what are landmark judgments, and how they have their impact onto your arguments or in your arguments. But then how do you do the research? I just Google the landmark judgment on rights of property of women, for example. I get a lot of cases. It gets buzzing onto the Google page. It starts probably before Fulawati's case. And then it stops to the recent or the current judgment, which suffices or which actually quashes all of the dilemma which has been there, whether women can get a property from by inheritance rather. While doing so, I just Googled, did I do any research? That's not called as a research. You ought to know the journals. I'm just not talking about the budding lawyers. We're actually talking about the lawyers. You will be the lawyers. You will be entering into the platform, which is a professional platform, wherein now you need to be quite serious about your research. For moot courts, chalta hai. Wo bhi nahi chalta hai, but any which ways. We just compromise at this stage. When we go onto the professional platform, Google definitely doesn't help you. You need to have some serious kind of the research. You need to have some serious kind of subscriptions to the authentic journals. You need to be well read. And what well read? You need to have subscriptions to certain magazines, certain journals, certain reporters. Reporters is reports, not the journalism wala reporters. So you need to segregate your elements, your journals, your reading material, your resource material, and then you have to develop your arguments. Researching also has the most, in fact, I would say it is one of the most significant stages to develop your arguments or develop those skills of argumenting. What kind of a research? That's true, but when do you research is also important. All of this research, if you are research, date hai. I have to go to the court and argument in front of the court. Tomorrow is the date. And today I'm researching. I am just mugging up whatever I receive. There is no time for the filtration. Worst is going to be your argument. When do you research plays a vital role. It is most important stage. When do you research? The moment you get the facts, the moment you corroborate the circumstances, you have the basic foundation of your arguments. The moment you have all of the deposition copies of the witnesses, that is the second stage where you have a time to research. And through these two stages, you come up to a perfect structure of your argument. So when do you research plays a vital role. But then again, when do you research? The very earlier day or the previous day of your argument till the previous day of your argument. If you're researching, you definitely are going to have a wonderful argument or structure of design of your argument. Why is that so? Probably there might be a case which just has been come up the previous day of your argument day, and that is going to be the most recent case law you're putting in front of the judge, the precedent which is going to prove your case. And that is why I say, to be a good lawyer with argument skills, you need to be a wonderful or an excellent researcher. Sometimes, they usually, many of my students or many of the law students, they come up and ask me, ma'am, we're not good in research, so can't we be a good lawyer? Of course you can be. Hire good researchers then. If you're not good in research, it hardly harms you, provided you are that intellectual to hire the researchers. So research plays a vital role. Is there any another element which helps you enhance your skills? Yes, the tools. What tools you utilize and how time you manage while structuring your arguments. So these days I say e-tools are the best tools which you can be well acquainted with. You are the next generation rather. So you're well acquainted with all the e-tools. Now all the judges rather also are well acquainted when it comes to the apex court, I must say. All of the judges. Now COVID has given us one of the beneficial impact, I would say. Isn't that? This is another side of the coin then, that we are now well acquainted with e-tools. Utilize them. You do not need to have big spaces in big spaces to preserve all of the materialistic things. The material can be e-material. You can actually utilize those while you argue as well. What is that? Another important, significant element other than e-tool which helps you build your skills. Research, yes. But then that research put up into a particular language. What language? Two things. The basic English. If you are into the trial courts, तुमसा English कैसा है? आप कैसे कौन से language में बात करते हो? It hardly matters because you can actually argue in the regional language. So if you are a Maharashtrian and you are well versed with your mother tongue, Marathi चांगली असेल तर तुम्ही मराठीत argue करू शकता. But the only thing is law is in English and then to convert it into Marathi probably might be a little difficult for someone, not for all. मला मराठीत बोलना सोपा वाटतं. मुझे बहुत easy and convenient mode लगता है जब मैं मराठी में बात करती हूँ. English I'm well acquainted with and hence probably that is my second easier language or convenient language. It all depends on the court in which you are arguing based upon the language which you shall be utilizing. Also, who says in the apex court only English is the language? You can be bilingual. You can utilize, of course, utilize two languages, one is Hindi and one is English, but then it all depends on the judge, the bench you are arguing in front of. And hence language, your vocabulary. You need to have a strong vocabulary when it comes to arguing skills. Not always the vocabulary needs to be the legal vocabulary. But then yes, it is one of those advantages, it is one of those beneficial elements or extra penny, I would say, into the whole ocean of your knowledge when you have wonderful legal vocabulary. So you need to enhance your skills of reading to be a great lawyer who has the wonderful skills of arguments. What do you mean by legal vocabulary? The phrases, the idioms, the terms, Latin terms, they work wonders, guys. If you're appearing in front of even a trial court and you are using all of those Latin terminologies and words, ask me, those work wonders. At least it gives an impression onto the judge that you are so well read. At least it puts up a little pressure onto the judge. Oh my God, the lawyer seems to be junior, but she is perfectly acquainted with and perfectly confident with what he or she wants to express. And hence, your vocabulary plays a vital role. That is one of those skills which helps you enhance or which helps you enrich with this argumenting skills or argumentation skills. Not going to make you more bored about this, but then the last probable one to talk about the skill for argumentation is your communication skill. I'm fantastic in research. मैंने बहुत amazingly research किया है. मुझे सारे फैक्ट्स जो है ना एक के बाद विद अ सीरीज सीक्वेंस याद है, मुझे सब याद है कौन से फैक्ट पे मुझे क्या आर्ग्यू करना है, कौन सा केस लॉ यूटिलाइज करना है, यूज करना है. आई एम वेल वर्स्ड विद ऑल ऑफ द पॉइंट्स. I have a script which I have along with me, based on which I shall be arguing in front of the court. But then I am not an extrovert. Once I go to the court, I am court phobic. I am formal phobic. I go to the court, even if the court is, the judge is not onto the dais, मुझे फिर भी phobia हो जाता है once the moment I enter the courtroom. You need to develop the skill. You cannot get away and run away from this particular skill. You're a lawyer. It's just not your communication skill, and it's just not your expressing mode, but it is actually a way or a subway for your client's expressions or client's conveyance to the judge. You're convincing the judge, not for yourself. It's for someone else. So you have a double responsibility. You need to prove yourself as well as you need, see, you're proving yourself as a lawyer, and it doesn't make any difference if you didn't prove it to be a good lawyer. Maybe next time you get a chance to prove yourself as a good lawyer. Maybe third time you get a chance to prove yourself as a good lawyer. But when I say you're proving someone else's case, that person is not going to get a second chance for this. So that's the responsibility, and hence you need to develop those skills if you are not well acquainted with, or you're not born with the communication skills. I can give you a simple तरीका. मुझे नहीं बात करनी आती, हजारों लोग जब सामने बैठे हुए होते हैं तो आई एम वेरी फोबिक. I cannot speak in front of thousands of people. I cannot speak in front of one person. Forget about thousands and lakhs of people in front of me. तो मैं कभी बात नहीं कर पाऊंगी. I can, of course, have a mirror talk. Your mirror, your reflection is your best friend. If you're not well versed with English, if you're not well acquainted with English as a language, use that language initially which you are more comfortable with. Talk to yourself in the mirror. Have 100 times practice to talk to yourself in the mirror. Second bakras or your family. Make your mother the very first to sit in front of you. Speak anything. Speak, if your mother, she is the one through whom you have a legacy, then that's a question mark. Usually make a person who is raw in law. Make him or her sit in front of you and start arguing. The third mode is make one ka do. Make two people sit in front of you. Then make your friends as a group sit in front of you and start arguing. And I'm talking about you actually being a professional lawyer. Forget about the moot court wala thing. You can utilize this for a moot court thing also. Once you start discussing, debating, arguing in front of your friend circle, friends group, I'm very sure the next moment you definitely can argue in front of a judge. Do not think as to he is a judge or she is a judge. Imagine your friend sitting onto the dais and argue, because you have a double responsibility. That is one of the modes of enhancing your communication skill, which is an integral part of your argumentation skills. Lastly, drafting. Now, these days, as I said, our times, the most convenient mode of argument was oral argument. But these days, more of provisions which help you rather are, lawyers are aware of these provisions that you can just file a written argument. You do not need to always orally argue in front of the judge, but that's the most impressive way to convince a judge when it comes to an oral argument. But hota hai, as I said, I'm not well acquainted, or I'm not very happy, I'm not very comfortable arguing orally. So what do is I prepare an excellent draft of my argument with hundreds of landmark judgments, hundreds of recent or current judgments supporting my argument. I prepare a draft, I recheck the draft, I format the draft, I edit the draft, and then I come up with a final draft, which I submit in front of the judge. Judge won't compel you to argue orally. However, the disadvantage of filing written argument, because that's one of the modes of arguing, isn't that? But the disadvantage is while you argue, or if it is a written argument, there is a little chance of rebuttal, or there is a little chance, rather there is lesser chance for a judge to ask you certain queries. If he or she has any queries into his or her mind, there is a little chance. The judges won't ask you to be present into the court, and they will ask you the query, okay, ये जो आपने submit किया है, इसमें ये जो point है, इसमें आपका क्या कहना है? They will definitely not bother, because you have not bothered to stand in front of them and bother to argue orally. They'll be least bothered. In this case, this is a disadvantage, and hence I always recommend my students, all of the lawyers must acquire the skill of argument. That's so simple. It's a mere art. No one is born with all of the features and characteristics. You need to boost up yourselves. You need to identify and self-determine what are you lacking in. You need to determine arguments क्यों नहीं करने आ रहे. What is that determination point? Am I bad in research? Am I bad in collecting the instructions? You won't be good in collecting the instructions in the very first initial stage of your professional life. Of course not. You won't be understanding also कि कौन सा instruction कैसे निकालना है. That again is something which comes up with an experience. Similarly, argument skills also experience के साथ आ जाते हैं. But basically, you should be prepared, because there is a saturation and there is an extreme competition in every professional phase. And hence, you need to groom yourself, polish yourself with all of these arts. One of the arts is argumenting art. So what do you need? First of all, just concluding this session, the first thing you need to understand, or while you enhance your skill, is you need to locate your goal. ठीक है, arguments है, but you need to determine certain questions. Based upon those questions, you need to build up a story. Based upon that story, you need to build up a material for that story. Based upon the resource material, you need to construct a theme for your case. Based upon that theme, you need to enhance it with a theory. And that theory, you need to mug up with various recent, current, landmark judgments and express it through, I would suggest, oral argument, but then that's your option, oral or written argument. While doing so, you need to be competent legally. What provisions? When I'm setting up a goal for my arguments, I need to know what all provisions I can actually implement or execute in this particular case. So you need to be well versed with the law as well. So what are those concluding elements for yours to be a fantastic lawyer with a superb or excellent argument skill? Is reading, interpreting, or rather reading, understanding, interpreting, comparison, critically analyzing, simply analyzing, structuring, designing with lot of vocabulary or fantastic vocabulary into the legal terminologies, and that is to be communicated, conveyed to the judge, rather in an impressive way. These are the modes, or basically these are the ways of enhancing your skills for the arguments. Research, facts, implementation or execution of this research to the facts, preparing those arguments and expressing the arguments. This is what is the art of argumentation, and that is actually covered up with every academic session of ours with the help of moot courts. So I would rather say help yourself more with participations in the moot courts, and you will be fantastically groomed for the argumenting skills. So basically, this is all from my side. Thank you so much. Thank you, Bharti Vidyapit. Thank you, Ujjwala ma'am. Of course, thank you so much, Karishma ma'am, and the students. Though I could not see them, but I hope that they have been interestingly and they've reached what I meant to say into this session. Thank you so much. Thank you.
Thank you so much, ma'am. Thank you, ma'am, for your deep insights and guidance to all of us on this argument skills, ma'am. You have given so many tips, even for the students, for the argument skills, which will definitely help them to improve their skills. And they, it is like a path which is given by you.
Thank you, Karishma
Yes.
ma'am.
So it was indeed an enlightening session. Thank you so much, ma'am.
Thank you. Thank you so much. Thank you, Ujjwala ma'am. Thank you so very much. And too eager to meet you one more time.
Madam, we have learned so many things today from you.
Thank you so much, ma'am. That's a compliment.
Thank you.
Yes. Okay. So now with this, we move ahead to the vote of thanks. Yes, so on behalf of Bharti Vidyapit New Law College Student Progression Cell, I take this opportunity to express my gratitude to our resource person, Dr. Sheetal Babar ma'am, for the most enlightening session. Thank you, ma'am, for giving deep insights about the challenges and advances related to this important topic. It was pleasure to hear you, ma'am. I would also like to thank Advocate Rajendra Umap sir, who spared their time from busy schedule to grace the occasion. Further, I would like to thank our Honorable Dean and in charge principal, Dr. Ujjwala Bindale ma'am, for the continuous support. Thank you, ma'am. A special thanks to all the teaching and non-teaching staff. A heartfelt thanks to all my dear students and everyone who have participated this webinar. Thank you, one and all. Thank you, everyone.
Thank you. Thank you, everyone.
Yes, thank you, ma'am.